All right. Hey, I'm not going to wait for everybody. It's going to be a really short video. As a lot of people know, there's a lot of discussion about what's going on with, this underage thing. I think all the other charges are going to go away. I also think the underage thing could possibly go away. He's got a really good attorney. But what I wanted to do is instead of talking about what I think or what you think or what all of the talking heads on social media think, let's go to the Wisconsin law itself and talk about what is the truth about whether Kyle was in violation as a minor. So under Wisconsin law, the section is 948.60, and I'll add this to the description underneath. Well, no, I'm not. 948.60, okay, is the Wisconsin law. And what this says is any person under the age of 18 who possesses or goes with a dangerous weapon, and this is subsection 2A, all right? Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. Now, legally, you have to ask, well, what's a dangerous weapon? Okay, well, it defines dangerous weapon. It means any firearm, loaded or unloaded, then it lists other things, but we're not concerned with those other things. So then, what is a firearm? And of course, it's a rifle, a shotgun, a pistol, and it describes a firearm. So instead of going into all that, I will just say that an AR-15 fits the definition of firearm. But when you're making a legal analysis of a statute to determine whether or not somebody is guilty of a crime, you have to go through that little mental exercise. So any person under the age of 18 who possesses or goes armed with a dangerous weapon, you got to find out what a dangerous weapon is. You got to find out, and that says firearm. Then you got to find out, okay, well, what's considered a firearm? Because black powders are not considered firearms. Is guilty of a Class A misdemeanor. Okay, so it would sound like right there that Kyle Rittenhouse is guilty of a Class A misdemeanor, right? However, if you go down to section 3C under 948.60, okay, section 3C says this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28. And I'm going to stop there. There's another section here that doesn't really apply, but I'm going to stop right there. So what does 941.28 say? Well, 941.28 is where it makes it illegal in Wisconsin to own a short-barreled rifle or shotgun without the proper paperwork. Okay, so nowhere in 941.28 does it say anything about age? Does it say anything about any of that kind of stuff? Okay, so unless you've been convicted of a felony or any of all that kind of stuff. So if you go back to 948.60, it says that the section applies to a person under 18 only if that person is in violation of 941.28. Kyle did not have a short-barreled rifle. Kyle did not have a short-barreled shotgun. Kyle was not a felon. Kyle was not mentally adjudicated. Kyle was not on drugs. Kyle was not intoxicated. Those are all the things that you're not allowed to carry when you're not allowed to carry a firearm. All those things apply. None of those applications in 941.28 apply to Kyle, which means that he was not in possession. He's not in violation, because in order to be in violation of 948.60, which talks about having a deadly weapon if you're under 18, then you've also got to be in violation of 941.28, which he's not, because it's not a short barreled rifle or shotgun. Or he has to be in violation or not in compliance with sections 29.304 and 29.593. Now, those sections are about prohibition or restrictions, excuse me, on hunting and the use of firearms by persons under 16 years of age. So that doesn't apply either, because Kyle was 17. So he wasn't under 16, and wasn't in violation of that section. So once again, the exception applies, and the under 18 law does not apply to him under that section. And then it also says unless you're in violation of 29.593, and that section just deals with if you're hunting without a hunting license. Okay, so none of that stuff applies here. It just doesn't. And also, by the way, it would have been a felony to the person that gave Kyle the firearm, because the firearm did not come across state lines. As we have learned from Kyle's attorneys, Kyle was he works in Kenosha as a lifeguard and was in Kenosha that day as a lifeguard. After his shift, he went to a local high school that had been vandalized and was cleaning graffiti off the walls and stuff like that. While they were there, one of his friends or one of the guys there mentioned that a business owner who owned a couple of mechanic shops had called and said that he would like some assistance protecting his businesses. So he was invited to be there as well, by the way. And the friend loaned him the rifle. So the rifle was always in Wisconsin. It never came from Illinois. It was always in Wisconsin. So not that it matters, because it's not a crime to transport a rifle across state lines. Not that it matters, but it does get rid of that ignorant, stupid argument from the left. It gets rid of that argument. It gets rid of what I just read to you, 94860, gets 3C specifically, gets rid of the argument that, oh, what's a 17-year-old doing with a rifle? That's against the law. He committed a crime. And I mean, these idiots are also saying it's a felony, even if he was guilty of that, because he had a short-barreled rifle. It's not a felony. It's a Class A. Well, it's a felony to have a short-barreled rifle, but then it's a Class A misdemeanor just to be carrying a deadly weapon. So I mean, it would have been 2 offenses at that point. So that's what I wanted to bring up. I wanted to bring up specifically what the law is about a minor carrying a rifle, because everyone's arguing all over the place online. And we've got all of these Facebook lawyers out there. And I'm not a lawyer. I'm just saying that. But everyone's spouting an opinion without spouting the law. And if you're going to spout an opinion either for or against this issue, you should spout the law. Now, my opinion is Kyle didn't break the law. And the reason is because 948.60 subsection 3C gives him an exception because he was carrying a rifle. If he was carrying a handgun, it would have been different. If Kyle had a handgun on him, he would have been in trouble carrying a deadly weapon. But he was carrying a rifle. It wasn't a short-barreled rifle. It wasn't a short-barreled shotgun. He wasn't hunting, and he wasn't under 16 years of age. If he was hunting, there would have been other restrictions on there. So there you go. There's a little brief analysis, 7.5 minutes. I don't think I have any... Even if his friend knowingly loaned a gun to a 17-year-old, Don, it's under Wisconsin law, is not a crime because it was not a short-barreled rifle. There's no law against a 17-year-old having a rifle as long as it's not a short-barreled rifle. All right, so go look at it yourself. You can go to docs.legis.wisconsin.gov, type in 948, go to chapter 948.60. Read that. There's only one paragraph that really applies. You can read the whole thing if you want. And then if you keep reading, go down to subsection 3, and then next subsection C. So 948.60, subsection 3C. That's the one that applies. And then you can click on, because it says this section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is in violation of section 941.28. And to be in violation of 941.28, you have to have either a short-barreled rifle, short-barreled shotgun. You must be under the influence of alcohol, drugs, mentally deficient, have been convicted of a felony, all the things that you're not supposed to have a firearm for, okay? And he was not in any of those. Thank you guys. Take care. Be safe. Be free. Like this video. Share it. And tell the ignorant people on your social media accounts to shut up or bring facts.